and then see what happens with the second one. And I will call it. It's State versus Modeste, and council can begin when you're ready.
May it please the court, I'm Wesley Height and I represent the state on this case. Excuse me. We're challenging the granting of the motion to suppress the statements made by the defendant in this case. I would like to reserve about 3 minutes for rebuttal, if I could. When you look at some of the background facts in this case, the defendant was a suspect in 2 murders out of Orlando. The defendant left the area, was found in Indiana. 2 officers from Orlando went up, talked to him in the interview room. When they interviewed him, this was all on tape. The officers Mirandized him. He gave various incriminating statements. When he was returned to Orlando, defense filed a motion to suppress, and in the motion to suppress, the 2 officers testified, the defendant testified, and the tape was played. The state brought out the fact there was a written signed Miranda waiver in this case. The first judge that heard the motion to suppress listened to it, made various findings that the Miranda was sufficient, and denied the motion to suppress. Subsequently, this court decided the case of Maxwell. A second motion to suppress was issued, and in the second hearing, all parties agreed that it was entirely a legal issue, and therefore review here would be de novo, as this court stated in Maxwell. And the trial court called it a very close question, but granted the motion to suppress, finding that the fact that the officers told him he had a right to counsel before, but didn't use the word during, made the warning in this case insufficient. And it's our position this is an incorrect ruling, and I'd like to explain why. The totality of the warning is what you look at. You don't look at the magic language. You don't look at any precise formula. For our Supreme Court, U.S. Supreme Court have repeatedly said that. So looking at the language used by our officers, you're entitled to talk to an attorney. If you want one, you can ask for an attorney. If you can't afford one, you know they can appoint one for you. You have the right to talk to an attorney. If you want one, we'll get you one. You look at Miranda itself. In Miranda, you have the right to the presence of an attorney. We supplemented with the case of Graham out of the second. You have the right to the presence of an attorney. This has been held sufficient. In our case, the officer then adds, of course, you can talk to an attorney first before we even talk to you. Because the officer added this phrase, before we even talk to you, you can bring in, we can get you an attorney in here. This would be the logic, our argument is the lack thereof, that using that phrase therefore reduces the entire Miranda warning into an insufficient warning. And I don't think that's consistent with the law. The court based its ruling on Maxwell. When you look at Maxwell, I think it's clearly distinguishable. In Maxwell, there was a question of a citizen encounter and whether the defendant was even in custody. In Maxwell, the defendant was encountered in the street. The officer Mirandizes him, tells him he has a right to an attorney before he talks to someone, never tells him that one will be appointed for him. There's no written waiver form. It's not on tape. We don't have to guess what our officer said in this case. We have it on tape.
What's the effect of having the written form in this case?
I think the effect is, if you look at what the factual findings from the judge in the first order, if you look at the written waiver, the judge talks about the officers turned the page towards the defendant. The officers took the written waiver and walked him through line by line by line. The judge says, there's no question in my mind, he voluntarily waived those rights. He was looking at them each time the officer verbally went over them. This is the judge's precise findings who watched the tape. This was the testimony of the officers. If you look at the defendant's testimony at that hearing was, I asked for an attorney outside. You know, it wasn't that I didn't understand before and during. This is something that comes out post-Maxwell. You know, this is a legal argument from counsel. The defendant's version was, I was asking for an attorney before we walked in there. And that's not what the judge found happened. He found the defendant specifically not to be credible. When you look, the waiver signed, the waiver itself, you're entitled to talk to an attorney now and have him present now or at any time during questioning. You're presumed to understand that. Look at the defendant himself. When the defendant here talks about being, there's testimony that he's dyslexic. A lot of people are dyslexic. That doesn't tell us he didn't understand anything. The defendant also, what's he doing when the shooting occurs? He's trying to collect rent. This is a landlord of multiple tenants. This is a landlord who, after he leaves the scene and goes up to Miami initially, and this is all in his own words in the admissions he makes. He goes to Virginia. When he goes to Virginia, I found it interesting. I ran and opened my own business basically when I'm hiding in Virginia. I've always been a businessman. I built it from the ground up, curtains and upholstery at large. We were making $10,000 a week. This is not someone who has a hard time understanding what's going on. This is someone who's able to start a business from his own words, from the ground up, and create a business making $10,000 a week. So he's someone who's successful, he's someone who understands, he's someone who signed this waiver. And this waiver gives him the full rights. But again, Judge Waddles in the second order calls it a very close call with Maxwell, but Maxwell is completely distinguishable. When you look, and I was looking at all the various cases with the Miranda, when you have a written waiver, I think that separates it. You have it on tape. This is not a citizen encounter. Maxwell ultimately sent it back down to see if he's in custody. Not in custody, no Miranda requirements. Our guy's in custody. Our defendant is sitting there in an interrogation room. He knows why he's there. We've gone up to Indiana to talk to him. We walk in, the officers Mirandize him, the officers tell him, again, you're entitled to talk to an attorney. If you want one, you can ask for an attorney. This is not an officer paraphrasing what he thought he remembered saying. This is on tape. This is him saying this to the defendant. If you can't afford one, we'll appoint you one. Again, that was not done in Maxwell. I think it distinguishes Maxwell. The state also cited to the court the more recent case of Octave. In Octave, this court found that if you're told you have a right to an attorney before and not during, that's insufficient. Very, very few facts in Octave. No mention of a written waiver, which I think would distinguish it. And in this case, we go with you have the right to an attorney. We'll appoint you one. We'll even get you one before we talk to you. I think clearly that distinguishes Maxwell, clearly distinguishes Octave. As pointed out in our briefs, the entire state is basically reviewing this issue. This line of cases came out of the 4th DCA. Even in the 4th DCA, they en banced the issue. And the case of Canetti, they said that if you have the right not to answer any questions at any time, you can speak to an attorney was sufficient. So where the cases that said before and not during was insufficient, they've arguably backed off, or with facts more similar to ours, found it to be sufficient. I found it interesting and cited in our brief the cases out of the 3rd where you walk into someone, you're about to interrogate them, you have a right to an attorney during our interview. The 3rd DCA says that's sufficient. But case law has developed where it says if you're told you have a right to an attorney before is insufficient. To me, when you look at it and it says we don't need formalistic, we don't need form over substance, that would seem to be exactly what that is. If looking at it in the real world, if I walk in and if the defendant says I want an attorney, it's there on record, and you give it an attorney and the attorney shows up, when that attorney shows up, the officer is going to say you now need to leave, we're going to interview your client. The right is almost greater if you give it to him before. So we think in this instance we covered both bases. You have the right to an attorney, we'll appoint one, we'll even give you one before. It distinguishes Maxwell, and we would ask that you reverse the trial court's order. I reserve the remaining time for rebuttal.
Thank you. You got about 6 minutes left.
Morning, Your Honors. My name is Frank Bankowitz from Orlando, representing Mr. Modeste. I was Mr. Modeste's attorney at the trial level as well as this level. And the situation here, with regard to this first motion to suppress, that motion to suppress was really directed at the Miranda sheet, in that the officers in completing that sheet checked each box inappropriately or wrongly. And that was the gist of that motion to suppress, is that Mr. Modeste in the paperwork said he wanted an attorney, that he didn't understand, and that he wanted his constitutional rights, basically. And the officers came into the hearing and said, oh, those are merely Scrivener's errors. The trial judge at that point said, on the basis of the tape recording, that yes, those probably were Scrivener's errors. But at no time was it argued that the issue before this court with regard to whether he had the right to an attorney before or during questioning. The state stipulated that he was never told that he had a right to an attorney during questioning. The word before is the only word that was used, and it's tracked in Judge Waddle's order. He could talk to an attorney before talking.
But was your client notified in writing that he had the right to an attorney during interrogation?
According to the officers, they read him the Miranda warnings. He did not read them himself. At that point, he told them that he was dyslexic, words were mixed up
Well,
in his eyes.
but he said, I do read.
I can read, yes, sir.
Okay.
Yes, Your Honor. He had said, I can read,
And
but
the written form is given to him for his signature, correct?
it was given to him for his signature. but
And he was also told he could read it, take his time reading it, wasn't he?
I believe he was told he could read it, and that's when he said that his eyes, the dyslexia makes his eyes mixed up.
Well,
And
let me ask you this. If the police officer said nothing, and they gave him the written form and said, these are your Miranda rights, can you read? He says, I can read. And they say, take as long as you want. And then after some period of time, and who knows if he's reading it or not, but after some period of time, he says, okay. And the police officer says, do you understand your rights? And he says, yes. Then is that sufficient? Does the police officer have to say a word as far as giving the verbal, giving Miranda verbally, or can the police officer rely on having the Miranda warnings given in writing?
under the facts Your Honor is giving me, that would be sufficient. He would have been given sufficient time to go over it, then questioned as to whether he understood it. That's not what happened here. He
Well,
was handed the sheet to sign.
How can Judge Waddles make that decision if he didn't take any evidence on it?
Because the transcripts were used of what happened, and I believe, if I recall, there was also a video that he was provided, which he reviewed, and it took him about 5 days to make a decision after reviewing all the transcripts, the video of the interview, and all the other evidence that was submitted in the first motion to suppress. And it was after, some days after reviewing all of that, that he made his decision and found that, in fact, Maxwell did apply. Now, our situation, I think, is even more egregious than Maxwell, in that Maxwell, it was kind of an off-the-cuff, officers giving someone their rights. Here, they've got a dyslexic individual with a 7th grade education, and he can sew, okay? The state makes a point of him being in the upholstery business. He can sew, he can make slip covers, things of that nature. That's menial labor. And the situation here is he's got a 7th grade education, he's dyslexic. They should have taken the extra time because they actually had the warnings there. They could have read them to him on tape rather than paraphrase them and given him each warning and said, do you understand it on tape, on video? Yes, I do. No, I don't. Whatever his answer may have been.
Okay, but let me ask you this. You agree he was given the written
He was given the piece of paper, yes.
written piece of paper. And he was asked at the end of whatever time period, do you understand these rights? And he said yes.
Yes.
And then he signed it. Now, there's 2 things that he said that went to reading comprehension. One is I do read, and 2 is I'm dyslexic. Can't pronounce it. And then there's also police officer's testimony that when they came into the room, he was apparently reading the Bible.
He was carrying the Bible, but be that as it may.
Okay, well, didn't one of the police officers testify that he was reading, appeared to be reading when he came in?
They talked about the Bible. To be honest with the court, I don't recall whether he was reading it. I remember them talking about the Bible and things in the Bible.
All right, if he just solely said, I do read, and then he signed it, and then he answered, I understand, and he signed it, would that be sufficient?
It possibly could be. But again, that's not what we're dealing with.
What are we
read the warning.
what are we supposed to glean from his statement that apparently Judge Waddles put some weight into, that I'm dyslexic? I mean, I don't know a lot about dyslexia, and there was no testimony about it, but I think from what I've read about it that there are varying degrees, and some people are dyslexic to the point that it is entirely disabling and they can't read at all. Other people are dyslexic and it doesn't impair them much. You know, the Richard Branson, the multi-billionaire. So it seems to me that simply saying I'm dyslexic is sort of saying, you know, I'm overweight or I'm underweight. I mean, there are degrees, and I'm not sure that we can really glean much from just that statement.
Well, possibly not from the defendant's statement, but when you look at the court order, which is what the trial judge took all factors into consideration here. He took dyslexia into consideration. He took the defendant's being in special reading classes with a 7th grade education. He quit school in the 7th grade. This is on page 2 of the court's order. Also, he took into consideration the mental hospitalizations and the depression of the defendant, and giving that somewhat weight or history as far as his situation went. And again, if these officers had just read that form verbatim to him on tape, on video, which they didn't do, they only paraphrased it, we wouldn't be here. There would be no problem.
Let's talk a little bit about the discussion that they had. If I'm understanding your position, your concern is that based upon some language in Maxwell, because the officers didn't say that you can have an attorney during questioning, that renders the Miranda warnings fatally flawed. Is that essentially?
That is essentially my argument, Your Honor. And
So let's talk about, I'm just looking at the transcript of what they did say. And let's take it in bits. The officer says, you're entitled to talk to an attorney, and if you want one, you can ask for an attorney. If you can't afford one, they can appoint one for you. Now, they go on, but let's just stop at that point. If that's all they had said, would that be okay under the cases that the state has argued here today, where there's no temporal limitation on it, it's acceptable?
That would be acceptable if they went no farther and did not put a limitation on it, which was the wording before.
Okay, so your concern then is in the next sentence where they say, of course, you can talk to an attorney first before talking to us. And so it's that additional sentence that takes an otherwise valid statement in your mind and renders it invalid.
Because it places a limitation on the first statement. And in the case the state cited out of the second, Graham, and the case that Graham cites, Powell versus State, 32 Florida Law Weekly, D 2418, it says, that case specifically says you have the right to talk to a lawyer before answering any question of our questions. We're constitutionally flawed because the right to talk or consult with an attorney before questioning is not identical to the right to have the presence of an attorney during questioning. So, you know, had they stopped and not put that limitation on him under Maxwell, under Powell, and even under Graham, it's fatally flawed.
Let's talk, though, about, if I understand correctly, Miranda was designed to accomplish a couple of things. Number one, to make certain that people understood that they weren't required to talk to the police, that they had a Fifth Amendment right to remain silent, and secondly, that they had a Sixth Amendment right to counsel. We agree on that?
We agree on that, Your Honor.
And essentially, at the end of the day, it's designed to prevent coercive police behavior. It just seems odd to me that we have this line of cases, for example, that say that the police can lie to defendants all they want about the underlying facts of the case and what other people have said, and you know the cases.
Yes, sir.
And yet, we're going to toss a statement based upon the use of the word before as opposed to the word during. But laying that aside, what impact, they go on to say in the same discussion, the very next thing that they go on to, they say, if at any time you feel uncomfortable or you think we're trying to persuade you to say anything, you can stop talking. If the whole goal is to get this fellow to understand that he's not required to speak to the police, which is the primary purpose of Miranda, as I understand it, the self-incrimination, secondarily, the Sixth Amendment right to counsel. I mean, don't you think from reading that this is clear that you don't have to talk to us unless you want to, and you can stop anytime you want? Laying aside the question of lawyers, I mean, I read this thing and it seems pretty clear to me that the police communicated, you don't have to talk, you can have a lawyer if you want one, and we can get one for you, arguably before, and if during the conversation you don't like what we're saying, you want to stop, stop. How is that coercive?
Well, I'm not saying it's coercive. You've got to make a differentiation between the two rights, the right to counsel and the right not to incriminate himself. And they're coexistent rights. And you can't just separate one out and leave the other one. And I believe that you've got to, they coexist. He has the right to counsel under the Sixth, and he's got the right not to incriminate himself under the Fifth. And you can't just separate them out. They coexist with each other. And the way it seems to me the court is coming forward at this point is that you want to separate those out and make them totally individual, and I don't think you can do that in this type of situation. They coexist. He has the right to both, not to waive one and have the other. Thank you, Your Honors.
Thank you, sir.
Thank you, counsel.
A couple points in rebuttal. You hear the defense arguing that he signed the waiver and acknowledging he signed the waiver, but then I hear the argument made, but he didn't read it. And he's presumed to have read it, it's shown to him, he's informed of his rights, and he signed it. There's no pressuring in this instance to put the type of decision on the officer, did he actually read it? Would be asking the officer to be a mind reader. That's not the legal requirement in this case. When you look at it, he was informed of his rights, he signed the waiver. Additionally, you hear facts discussed from Judge Waddle's order. We talk about, defense admits the fact that when you walk into that hearing, it said this is entirely a legal hearing. This hearing was based upon this court's case in Maxwell. In Maxwell, this court held that using simply the language before, not telling me he has a right to also have an attorney appointed, and was insufficient if he was in custody and they remanded back down. Again, not the facts of our case. Then you hear them talking about this defendant and all those facts that were developed from where I don't know. Judge Waddle's order, to be a completely legal order, has a lot of facts that were not developed in any hearing with the state's presence. The fact that the defendant had issues later is irrelevant as to what came down in this interview and what he understood and what he waived. If he later was incompetent, so be it. At that interview, he listened and was found in the first hearing to have understood and to have waived. When you look at helping prove the point as far as the facts, at the first hearing, so he was reading the Bible. I thought he could read it, said the officer. This is the version that the first judge believed and found to be credible. Those are the facts that he signed a valid waiver were based upon. The second order is based upon Maxwell. We think Maxwell is page 17 of the first hearing, the officer testifying as to what the defendant said. When you look at the language of our case, you're entitled to talk to an attorney. If you want one, ask for one. Okay? We have a written waiver. This is different than Maxwell. This case was based upon Maxwell. Even Judge Waddles called it a very close call. If it's close, then I can distinguish Maxwell the way I have. I don't think it's as close as the judge thought it was. We think it's, in fact, an incorrect legal ruling. We think that the ruling in this case would be the exact thing the U.S. Supreme Court said avoid, strained and literalistic. If you have a right to talk to an attorney is not sufficient. If signing a written waiver is not sufficient, it's hard for me to envision something that is so strained and literalistic. We would ask that you reverse the trial court ruling and deny the motion to suppress. Thank you.
Thank you, Mr. Chairman. Thank you, counsel. That was well argued.